Hi, my name is David P. Shapiro. I am a San Diego criminal attorney. I'm also the owner and managing partner of the law office of David P. Shapiro. And today in this video, I want to discuss with you some defenses to child molestation charges, particularly in San Diego. And there are two main ones. The first, what the child said happened did not happen. They are either lying or they're mistaken. And the second is what the child said happened did happen, but there was not wrongful intent on your part, the part of the accused. So let's break that down a little bit. The first one talks about, well, it didn't happen. Well, yeah, a lot of times people come in, they'll say, well, there's no evidence. Well, listen, if a child or their parent or somebody who allegedly witnessed something comes in and testifies to it, that's evidence. Make no mistake about it, that is evidence against you, and it's evidence that you have to deal with. You can't rest on the belief that, well, there's no evidence, because evidence is testimony, and that's exactly what it is. So a good defense is, well, things didn't happen. It just didn't happen at all, or I don't even know that child. Or yeah, I know that child, or it could be my child, it could be my girlfriend's child, it could be a neighbor, but it did not happen. The best way to defend against that is to keep your mouth closed when you're accused of it. Politely decline to answer any questions. You don't want to say, yeah, we were alone in my room, but nothing happened. Or, yeah, there was a time when I went over to her house and her mother wasn't there and I stayed in there for 10 minutes. Even if you're not admitting to an actual crime, look what you've just done. You've said you've been in the house, you've been alone with them, you've added some validity to this child's claim. You put yourself maybe not all the way there to commit a crime, but you establish the fact that at least some of what this individual said is true. Keep your mouth closed. Don't make a statement. Certainly do not make a statement without the advice and counsel of a quality, locally experienced attorney who's had success like we have handling these types of cases. The other type of defense to a child molest charge, particularly in San Diego, is, well, maybe things did happen that way, but there was not sexual intent. Now, that's pretty difficult to argue if it's an actual sex act, okay? But if it's a situation where the child says, well, he brushed up against me and put his hand on my behind or touched me there, there's some stuff to work with as long as you keep quiet and don't give them evidence that they already would not have. They have to prove, the prosecution needs to prove that you had wrongful sexual intent to either arouse yourself or arouse the child. So if it's a harmless incidental contact or contact without wrongful intent, that is a viable defense. A viable defense which could help you beat the case altogether. But you certainly need the help of a top-notch lawyer when charged with child molest offenses, particularly in San Diego. I encourage you to give my firm a call, 619-295-3555.